great. Well, good morning, everyone. Wherever you are, hopefully you're in a more comfortable location than I am, surrounded by boxes that are being unpacked. My name is Andrew Brown. I'm a barrister at Regularity Chambers. I'm joined by the estimable Master Daniel Thorpe. Young Master Thorpe here has decided that we should go without ties. It makes us look commercial and young, which works for him, less so for me. So welcome to a casual junior program on this fine Thursday morning. I'm going to be speaking about IVAs, challenges to IVAs, and specifically the case of Re Rossi, which I was in about 2 months ago. We'll go through some of the aspects of IVAs, how they're formed, how they can be challenged, and the facts of Rossi. Dan is going to then talk about winding up petitions in the post-CIGA world. It would be a really useful reminder for dinosaurs like me as to how we actually do winders. I think that will probably be the more informative talk of the two. Now, with that being said, I'm going to go ahead and share my screen and power on with this talk. Good stuff. All right. Well, so as I said, I'm Andrew Brown from Regularity Chambers, and we're going to talk about challenges to IVAs in the recent case of Re Rossi. So what are we going to do? What's our plan of action today? Today's a junior program. We've only got about 20 to 30 minutes to actually talk about IVAs. So it's going to be a whistle-stop tour, what my colleague Chris Buckley likes to call a quick and dirty tour through IVAs and how to challenge them. We're not going to go too in depth. I'm not going to spend a great deal of time going through specific cases. A lot of that obviously can be found in the secondary literature, especially the insolvency litigation book that Radcliffe Chambers puts out. There's a great chapter in there by Chris Buckley all about challenging IVAs. So if you want in-depth research, look there. I also know there's a recent book from a competitor on IVAs as well, which no doubt you can also look at if you want. But what we're going to talk about is what is an IVA and why people use them. Basic stuff, but some people don't necessarily know that. We're going to talk about the process of IVA approval and or its rejection, and then talk about the challenges to IVA. So how can they be challenged under Section 262, the Insolvency Act, either for unfair prejudice or material irregularity, or we're going to talk about challenges under the Insolvency Rules, specifically challenges against the chairman of meetings admitting votes or not admitting votes. And then we're going to talk about the recent case of Re Rossi, which I was in back. Judgment was handed down by ICC Judge Mullen in May. The hearing, I believe, was actually at the end of February, early March, memory serves. We'll talk about the facts and we'll talk about the decision in that case. So moving on. So what is an IVA? Well, most of us know this. We come across them quite often, but they're a contractual arrangement between the debtor and their creditors, which will be overseen by a third-party supervisor. These are backed by statute. The Insolvency Act and the rules specifically make provision for IVAs, so they fall within the insolvency regime. In essence, what they are is it's a written proposal that a debtor puts forward to their creditors, whereby they offer to essentially pay a certain proportion of the debts of creditors according to a plan of action. Now, often that can be either through the sale of property or third-party funding of some kind, something which essentially allows the debtor to pay their creditors over a period of time equally. So it's not just an individual agreement between one creditor and the debtor, but it applies to all creditors of the debtor. And the point is that it can be used to stave off bankruptcy. It's essentially an alternative to that. It binds all the creditors within the IVA. So if it is accepted, the creditors are bound by the terms of that IVA. It prevents them from, say, presenting winding up petitions for their debt, because that debt has essentially been compromised or compounded within the IVA. It's overseen by an insolvency practitioner, usually as the supervisor, who essentially makes sure that the terms of the IVA are being complied with. Again, usually that's a staged payment scheme. So the IP supervisor will be making sure money is being distributed to creditors at particular times and particular amounts, whatever the proposal sets out. And if that proposal is breached in some way, shape, or form, then the supervisor steps in to terminate that IVA and often presents a bankruptcy petition off the back of that. That's usually a requirement of any IVA. If it fails, then the supervisor has to present a petition. It's the kind of thing that we deal with quite regularly, supervisor petitions. These things do fail, so we do deal with them quite regularly. So that's an IVA in a nutshell. It's essentially a contractual compromise between a debtor and all their creditors. Why do people use them? Well, if you do it before bankruptcy, it's a good way to avoid bankruptcy, obviously. If you know you're in some sort of financial difficulties and you're likely to be facing a bankruptcy petition or are facing a bankruptcy petition at the moment, then it's a good way to reach an accommodation with all your creditors to avoid that bankruptcy. If you're already bankrupt, then you can still get an IVA. And in fact, the useful thing about getting an IVA once you're bankrupt is it's a mandatory annulment. Section 261 of the Insolvency Act requires the court to annul any bankruptcy if an IVA is approved. Well, why would creditors actually agree to an IVA? But again, that's a relatively straightforward answer. It's often a better return for creditors than there otherwise would be in the bankruptcy. And there's a certainty to an IVA. And there's always the backup of bankruptcy if it fails. What you get in an IVA is you get a knowledge of what you're going to get for your debt. You know, you're going to get 80, 70%, whatever you are owed. And you know where that money is going to come from, and you know when it's going to come. Whereas in a bankruptcy, who knows what's going to happen at the end of the day? If an individual's made bankrupt, maybe you'll see realizations, maybe you won't see realizations. And maybe the trustee's remuneration will eat up most of those realizations. Maybe it turns out they don't have assets themselves. But if an IVA is proposed and that IVA is third-party backed, then you're likely to see something, a realization. So it's a way of mitigating risk in an insolvency. So for creditors, it's often a great situation. It's likely, I think, that we're going to see an increase of these. We've talked recently about the likely increase in bankruptcies with the way things are going at the moment. We obviously saw a significant reduction in bankruptcies and corporate insolvencies during the coronavirus pandemic for many of the reasons I think we all know. But we are seeing, at least colloquially, I'm seeing more bankruptcy petitions these days than I did in the last few years. I'm certainly advising on more matters. So there seems to be an increase, at least from my perspective, on what's happening. And likely, if you see an increase in petitions, you're likely to see an increase in IVAs as well. So I expect these to increase in the near future. Well, how is an IVA approved or not approved? Well, the first thing is the proposal is prepared by an insolvency practitioner. Just so you know, on my slides, I use IP for insolvency practitioner. Straightforward, but just in case anyone's confused, that's what that means. Usually, almost invariably, the person who helps to put together the proposal for the debtor is the proposed supervisor, or what we call the nominee of the IVA. They themselves will chair usually the meeting of creditors. So notices are then sent to all creditors for a creditor's decision procedure. This is not a deemed consent procedure. We're very used to the deemed consent procedure in most aspects of insolvency. It's not available in this case. You actually need a creditor's decision procedure, but not a physical meeting, as we don't do physical meetings anymore, harkening back to the changes of the 2016 rules. A proposal sent to the creditors sets out various details. It sets out the full details of the debtor's financial position. So the debtor will sign and swear that certain assets are theirs. They'll set out the full amount of what they actually have. It's incredibly useful, IVA documents. This is an aside if you're dealing with issues of insolvency, bankruptcy investigations, and someone proposed an IVA previously, perhaps it failed. It's very useful to say what they said their assets were at that time. If they're subsequently made bankrupt and tried to resile on that and claim the assets that they previously said were available for an IVA are actually their spouses or their children's or someone else, it's very useful to look at IVA documents for failed IVAs. That's an aside for investigative purposes. However, that financial proposal will set out what the creditors will receive. So it says what the assets are available for distribution, which assets will be used for distribution, whether any third-party funding is going to be provided of some kind, where it's going to come from, how much is going to be there, and it's going to set out what creditors will get. So I've used the example of creditors receiving 80% of their debts through the sale of a property or provision of funds by a spouse, wherever, whatever. And then a comparison is set out between what would happen in the IVA and what would happen in bankruptcy if bankruptcy were to happen. So it's essentially a theoretical matching of the two. Usually, almost invariably, the IVA proposal will say that the IVA is better than bankruptcy. Most IVA proposals I've seen usually put it in single digits for the potential return to creditors under bankruptcy, whereas the IVA obviously says that it's going to be a great return But you need to have that comparison in there. And it's a useful comparison if you're looking at these things from a creditor's perspective. Notices, this will come back when we talk about Re Rossi. Notices must be sent out in a sufficient amount of time and state the name, the location, and the time of the meeting, how to join the meeting. Usually you send out the proxy forms, proof of debt forms, so you give instructions as to how to prove your debt, as you need to give details of your debt to any insolvency practitioner nominee. You need to send in a proxy form if someone is going to be your proxy at the meeting to vote for or against the IVA. As we'll talk about in Rossi, if you're sending proposals to an individual who might not speak English, there's no need to necessarily translate those matters into another language. What about voting at the IVA? So again, I'm doing a whistle-stop tour, so I'm not going to take you to all the specific provisions or set out the text from the rules or the act here. But the nominee acts as the chairman of the meeting and has the power to admit or reject in full or in part all of the debts which creditors try to prove for the meeting. So creditors send in their proof of debt, claim that they're owed X amount of money. The nominee has the discretion to admit or reject those proofs. Usually that will depend upon a comparison of, say, what's in the proposal put forward by the debtor, the substantiating information given by creditors. We all know when a proof of debt goes in, often you're supposed to put behind it the evidence of how that debt is substantiated. If it's a contract, say, if it's a guarantee, this will come back to Rossi. If it's some sort of judgment debt, you put the order of the court behind the proof of debt, something substantiating what the debt is and its quantum. And the nominee will look at that, and if there's enough to substantiate it and there's no objections to it by anyone, then they'll usually admit, but they might look at it and reject it for other reasons, or if someone raises an issue with it. If there's unliquidated debt, say a contractual damages claim, which is out there somewhere, they're to be valued at £1. So liquidated debts come in for their full value usually. When it comes to actual approval, so everyone then votes on the IVA proposal at the meeting, either themselves or via proxy. Approval requires 75% of creditors, the total value of creditors, of those voting. Associates can vote, but if more than 50% of non-associates vote against the IVA, then it will fail. So in essence, this prevents a debtor packing the vote with associates who are pushing for the IVA. And if a majority of non-connected or non-associate creditors don't want the IVA, that will stop it, regardless of the number of associates who are out there. So 75%, quite a high threshold to get to. Again, we'll see this in Rossi, people get close. 75% is a significant percentage. And there's a reason it's a significant percentage, because ultimately you're binding all of the voting creditors by this proposal. So you need essentially a supermajority in order to ensure that all creditors, it's a fair means of binding all creditors. If you had 51% as opposed to 49%, some would say that unfairly prejudices creditors in general, that's 49%, because they are a significant minority. So how does the IVA proceed? Well, IVAs proceed according to the proposal, with distributions to creditors at various stages until the full sums under the proposal have been distributed, at which point the IVA ends. That's in the perfect world. Everything goes smoothly, all the money goes out, the IVA covers everything, and the debtor essentially emerges the other end. All debts have been paid and compromised in the IVA, and they're free from financial constraints. If the terms of the IVA are breached, however, and usually not remedied quickly, then the supervisor will terminate the IVA. It's then almost a certainty that the supervisor will present a supervisor's bankruptcy petition against the debtor, will go to court on the matter, and almost invariably a bankruptcy order will be made unless the supervisor terminated the IVA incorrectly. So I've certainly had fights as a barrister acting for supervisors on petitions where the debtor shows up and claims that actually the IVA was being complied with, disputes the facts, and then you get into a factual matter as to whether the IVA had been breached or not. The supervisor can ask to be appointed as the trustee in bankruptcy. They need to give their consent to do so. If you act for a supervisor and who's brought a petition off the back of a failed IVA, make sure if they always ask if they want to be the trustee in bankruptcy, and if they want to, make sure that they give proper written consent, and that's included in any witness statement. They essentially have to apply to do so. Routes of challenging the IVA. So as I noted, this is more getting into the substance of this talk, but by the nature of a 75% required to approve an IVA, there's at least potentially 25% of creditors out there, or at most 25% of creditors out there who disagree with the IVA, who don't want to be bound by it, don't want to have their debt haircut, or might assume that in a bankruptcy it would actually be better, or they want a bankruptcy to come in so a trustee can investigate the affairs of the bankrupt. A number of creditors will want that. So the way the Insolvency Act and the rules allow for a mitigation of damage or prejudice to the significant minority who vote against an IVA is to give them a chance to challenge the IVA. There are essentially two routes to do so. There's the statutory route under the Insolvency Act, and then there's a way under the rules. Under the Act, you get Section 262 of the Insolvency Act, which itself has two elements to it, two subsections which allow different kinds of challenge. The first of those is a challenge due to unfair prejudice to creditors. If the IVA is approved, this only applies if an IVA is approved and a creditor says it unfairly prejudices them, then they can apply under this section and subsection to set it aside. Subsection 2 also accounts for material irregularities as to the procedure. So if there was something wrong with the very process of approving the IVA in some way, shape, or form, notices not being sent properly, votes not being counted, something to that effect. We'll look at examples in a second. That's an entirely different kind of challenge. There's also the challenge under the Insolvency Rules, 15.35, that allows challenges specifically to the decision of the chairman at the IVA meeting in admitting or rejecting votes. This will come back to Rossi in a second. So that's not actually necessarily a challenge to the prejudice which is being suffered, although that is an element of 1535 appeals, but you're looking specifically at the admission or rejecting of votes. So let's dive into that a little deeper. This slide has a ton of text. Sorry about that. I do like my small lettering. Section 262, two different aspects of the challenge: unfair prejudice and or material irregularity. Often people go with both in their applications. Unfair prejudice only applies where the IVA is approved. I've already said that, but important to really stress that. There are ways to challenge IVAs not being approved. Again, we'll talk about that with Rossi in a second. It's concerned with the creditor or class of creditors being unfairly prejudiced. So it prevents the majority essentially screwing over the minority in some way, shape, or form, cramming them down, to use the language of the restructuring tool. Some famous examples we've seen in recent years, at least in the context of CVAs, where, say, the majority of creditors essentially prejudice the rights of landlords. So they reduce the rights of landlords to forfeit or terminate leases, while also haircutting the amount of rent which is due and payable to those landlords. So it's unfairly prejudicing their contractual rights beyond what debts are actually owed to them. That's been held to be an unfair prejudice. Where it gives one specific creditor, say, a higher percentage as a quote-unquote critical creditor without good reason. So it is allowable in IVAs to treat different creditors differently. You can have one class of creditors who, say, receive 85% of their debt because they are critical to the running of the company. You say a key supplier to the company. And if we don't pay them more, then the whole IVA will fail. Again, this is in the context of CVAs as opposed to IVAs, but it is analogous to an IVA. And other creditors who are not critical, say not important trade creditors of some kind, are given a lower percentage than the IVA. That's been held to be fine if done properly, but if, for instance, you are entering an IVA and you say that your mother is entitled to 100% of her debt because she's critical for some reason, and all your other creditors only get 50% of their debt, and you don't give good reason why, well, that would unfairly prejudice the other creditors. So that's obviously an extreme and ridiculous example, but that is the kind of thing which sometimes happens. So that's been a case. Conversely, there's the example of crown creditors, so HMRC, essentially having their debt slashed in the IVA. being told that they can only receive, say, 25p on the pound, whereas all other creditors will receive 75p on the pound. Again, you're singling out an individual creditor, in that case the Crown, in reducing their debt without good reason. That's been held to be an unfair prejudice. Those are just some examples. What about material irregularity? Well, as I said, material irregularity is exactly what it sounds like. It must be some irregularity of some kind in the process of approving the IVA, which was material, which means it was likely to have affected the vote in some way. This is a fun use of likely. Likely in this context does not mean on the balance of probabilities, unlike likely in other aspects of the law. Likely in this case does not mean 51%. It merely means a substantial chance of having affected the vote of the IVA in some way, shape, or form. Some examples are failures to disclose material in a proposal. So maybe failures to disclose what assets you might have that would be available otherwise in a bankruptcy. False promises, false material in a proposal, so essentially fraud on the proposal. Failure to give notice to all of the creditors. It might be that a debtor only tells his supervisor of half his creditors, the ones he thinks will approve the IVA. It doesn't tell the supervisor of the other half. And so the IVA procedure is essentially functus just by not having the proper number of people there. Mistakes in calculating the voting rights, that would be a mistake by the supervisor, the nominee. Fabrication of debt, so someone making up a debt that didn't actually exist, or allowing or disallowing votes. These are the kind of examples that you would see coming out of material irregularity. So if you can prove this under section 262, you can revoke the IVA. Well, the court can revoke the IVA, and it can invoke a further creditor's decision if it thinks it appropriate, taking into account the issues which gave rise to the appeal. I.e., the court might say, okay, we're going to have a new creditor's decision, but because that debt had been improperly calculated, actually it's going to be calculated at this amount. Or you now have to give proper notice to all these creditors who did not receive notice previously. Those are some examples of what the court might do. But what about 1535 under the Insolvency Rules? This is, as I said earlier, concerned specifically with the admission or rejection of specific creditor claims at the meeting and the quantum of those claims. It's not a review of the process by which the nominee actually went in ascertaining the debts. The court will actually decide de novo what the proper quantum of a debt is and whether it exists or not. So it is essentially a trial of fact in many ways. The court can and usually will review evidence which it didn't have, which the nominee simply didn't have. This again is Rossi. Enormous amounts of evidence were put in which was not available to the nominee as to the existence of a specific alleged debt. Ultimately, it comes down to an issue of balance of probabilities, whether a debt is owed, and if so, what that amount might be. The court can order a new meeting, or can make any such order as it thinks just if it finds that there was some sort of issue. The court can approve an IVA if it revalues the votes of a failed IVA. So a difference between section 262 subsection 1, where we talked about unfair prejudice, that only applies when an IVA has been approved. 1535 can apply where an IVA has not been approved, where it's failed. This again, we will talk about Rossi in a second. The court can look at the votes and say, well, actually, this vote should have been admitted and the IVA should have been approved. So we're now going to essentially approve the IVA. However, this goes back almost to 262. The court will only exercise its power where the voting rights amounted to an unfair prejudice or material irregularity. So it's tied in many ways to 262. You look to the same issues of material irregularity and unfair prejudice. So ultimately, if there was an issue in the way a debt was calculated, would it have affected the IVA? If a debt should have been admitted for £1 and that wouldn't have affected the IVA, that would not be a material irregularity. If the IVA, the same goes for unfair prejudice, ultimately you have to look to see what the result would have been. The court will not consider itself with trifles which would not have affected the IVA. Time limits. So you've got to get on your horse if you want to challenge an IVA. You've got 28 days from the decision procedure to do so. That's the general rule. Both 262 and 1535. Get on. You've got a month to do it. If, however, you haven't gotten things together in those 28 days, Section 376 of the Insolvency Act does allow the court to extend time limits for personal insolvency issues, not necessarily for corporate insolvency. So it's different in that regard from other areas involving corporations. The court will apply the Denton test to any application to extend time, so it's not necessarily an easy thing. You want to get on this as fast as possible, so if you miss the 28-day window, don't dither, get it as fast as possible. So 2 months were approved in the case of Tager. 9 months was not approved in the case of Timothy. We all know the test in Denton and White. We all know the White Book rules on these things and the commentary. The longer this matter drifts past the initial deadline, the less likely it is for the court to approve it. And there must be a good reason, obviously, why you couldn't do something in 28 days. Say the gathering of substantial evidence which is needed to prove or disprove a debt, something to that effect might apply. Or the serious illness, maybe, of a creditor who is unable to actually instruct solicitors for some reason, maybe that would apply. The normal sort of rules. So let's talk about Rossi. This is actually, I think, why some of you might be here to actually hear about Rossi. Rossi was a recent case. It was heard, I believe, if memory serves, I think we dealt with this on the 1st of March in 2022. In fact, it was the day after the invasion of the Ukraine, which was interesting because essentially this involved Ukrainian, Russian, and English individuals. So what were the basic facts? Well, Mr. Rossi proposed an IVA. Mr. Rossi had a significant number of creditors out there, and Mr. Rossi did a significant amount of business in Russia and Ukraine. There were 2 different creditors who took divergent views on this IVA. There was Mr. Karapetian and Mr. Foster. Mr. Duffy was the nominee, so he was the local insolvency practitioner who put together a proposal and ultimately acted as the nominee and chairman at the meeting of creditors, admitting or rejecting votes. Mr. Karapetian was a Russian businessman who did not speak English and was in Russia at the material time. In fact, I think he was in Vladivostok, if memory serves. He claimed to have a debt of around £1.7 million. It's not quite that because it was split between both pounds and euros. Mr. Foster is, if memory serves, a Ukrainian businessman with a claim for roughly 1.1 million and had an outstanding bankruptcy petition against Mr. Rossi. So there was a petition on the table, and it was in the face of this petition that Mr. Rossi was seeking the IVA to avoid his bankruptcy. On the 17th of June, Mr. Rossi proposed an IVA. Initial notices were sent on the 5th of July. However, the first meeting of the IVA was adjourned to allow all creditors to participate because not everyone who was in the proposal as a creditor had kind of responded at that time. On the 16th of July, further notices were sent specifically to Mr. Karapetian. That notice was sent via email, including blank proof of debt forms and instructions in English. These were sent to Mr. Karapetian. The email which was sent to him was sent with a Google Translate text, essentially in the text of the email, setting out when the meeting would be. If memory serves, the text of that Google Translate essentially changed the time, which said that it would occur, I think, at 11 o'clock British summer time to 11 o'clock Moscow time. Google Translate just did that. And it was sent. It also contained a disclaimer that this was being done via Google Translate. So the person sending it, the member of staff from Mr. Duffy as the IP, said he doesn't speak Russian. He had to use Google Translate, so he wasn't sure if it was being properly done. So what then happened? On the date of the meeting, the 19th of July, a few things happened. The meeting was scheduled to commence at 11 a.m. Mr. Karapetian was in Vladivostok, claims that he thought the meeting was going to occur at 10 a.m. or 11 a.m. Moscow time, which would have been 3 hours before the actual meeting in London. So it would have been 8 a.m. London time. Well, he sends 3 emails to the nominee between 9:51 and 9:57 British summer time. So just a few minutes, I apologize, sorry, the meeting started at 10 a.m. Just a few minutes before the start of the meeting, he detailed in those emails a debt of £500,000 under a loan agreement. The loan agreement was sent and documentation was sent actually substantiating that loan. Again, just a few minutes before the commencing of the meeting. Mr. Rossi, the meeting commences. Mr. Duffy receives these emails, staff receive it. He admits Mr. Karapetian's debt for £500,000, which is the only thing that had been sent to him. And Mr. Rossi, who's there and is the debtor, is essentially starts trying to get the attention of Mr. Duffy as the IP, saying actually the debt is much greater, and he has documents in his possession on his phone which actually show that Mr. Karapetian's debt should be around £1.7 million, allegedly under a guarantee of other corporate debts that were said. It was said that Mr. Rossi had guaranteed various debts owed by a company that he controlled, allegedly, to Mr. Karapetian. But the nominee refused to look at those documents or accept them from Mr. Rossi, having not received them from Mr. Karapetian. So the meeting ended an hour and 15 minutes later at 11:15. The proposal was rejected. So 72.3% voted for it and 27.7% voted against it. Essentially, Mr. Foster voted against it, and that is what sunk the IVA proposal. So you can see what the issue is. Had Mr. Karapetian's debt been admitted for £1.7 million, it would have swung the matter. It would have gone over the 75% because it was a near run thing. So Q issue, whether the debt should have been admitted in full. I should say what's not on that list of facts is that then that afternoon at roughly 2 p.m., Mr. Karapetian sent a further email to the supervisor detailing the further particulars of his debt claimed under the guarantee. But of course, that came after the meeting had been concluded and after the vote had failed. So what happened? Well, Mr. Karapetian appealed under Section 262 and Rule 15.35 under two essential issues. One, he claimed that the guarantee debt, which had not been admitted by the trustee or not been admitted by the supervisor, in fact, had not even come to the knowledge of the supervisor at the time, was a real debt. So that was an issue of fact. Claim that he was owed roughly, I think it was 1.1 million euros under this guarantee. It was a handwritten guarantee in English. And there was issues then as to whether, in fact, a corporate debt existed, whether the guarantee was real or not. There was also an allegation of material irregularity involving the actual provision of the meeting. It was claimed that the nominee should have or had failed giving proper notice to Mr. Karapetian. He was misled by the Google translation as to the time of the meeting, and that the nominee should have had regard to the documents which Mr. Rossi, the debtor, was trying to give him in the meeting to substantiate further sums owed to Mr. Karapetian. So we had a whole day hearing in March on this very matter, and it was split into two different elements. There was the factual issue as to the debt under the guarantee, and then there was the material irregularity issue involving the nominee. The nominee was neutral as to the issue of fact. That was merely a fight between Mr. Foster, who said that the guarantee was not a real debt, claimed to have knowledge on the matter, and Mr. Karapetian. Mr. Karapetian was supported by witness statements, both by himself and Mr. Rossi, trying to substantiate that debt. The second issue, the nominee, Mr. Duffy, my client, fought on, saying that there was no material irregularity and that everything had been done properly, and that the fault essentially lay at the feet of Mr. Karapetian in failing to substantiate and provide details of his debt. And essentially, he waited too long and didn't give proper notice of what his debt was, and he clearly should have known how to provide the information. So what did ICC Judge Mullen ultimately find? Well, first, the factual issue, which didn't concern me, so I'm not going to go into any depth on it because my memory is very poor on it. But in essence, on the facts, he found that no debt was actually owed under the guarantee. So this claimed greater debt from Mr. Karapetian under the guarantee simply didn't exist in the eyes of the court. There had been legal wrangling in the case between myself and my learned friend, from Mr. Karapetian, as to how the court should approach the matter. We said that it is based on a previous case of Re McNally. It is an issue of balance of probabilities, as I said earlier in this seminar, that it's essentially the court has to decide that there is more likely greater than 50% chance that's what likely means in this case, that the debt did exist, and the court agreed that that is the proper approach for the court under these circumstances. It must look on the balance of probabilities as to whether a debt existed or not, as a matter of fact, looking at all the evidence now. And ultimately it decided that it didn't exist. What then regarding material irregularity? Well, at the very end of the judgment, the judge dealt with this matter. The first, and this is the first good takeaway from this case, there's no obligation for the nominee to translate documents from English into another language for the creditor. That's quite useful, especially in the world of international debts. It's not required for the nominee to get some sort of professional translation done of the documents to send out to the creditors. That's a matter for the creditors to try to translate them if necessary, if they can't speak English or can't read English. He found that the giving of the wrong time in the Google Translate of the email attaching all the various documents to Mr. Karapetian was an irregularity, but it was not ultimately a material irregularity. Mr. Karapetian could have provided proofs of his debts in detail at any point prior to the meeting. In fact, he did provide, as the judge noted, some information prior to the meeting. What was not explained in the evidence is how, if Mr. Karapetian thought the meeting, as he claimed, was commencing at 10 a.m. Moscow time, which would have been 7 a.m. British time, he sent the documents at 9:51 to 9:57 British time, so just 3 to 9 minutes prior to the meeting of creditors in London. This is not explained as to how his mistake actually worked out that he managed to send the documents in proper British time. And it doesn't detail why or how, having received all the documents days before the meeting, he waited until the very last minute to try to send documents. He had ample time to do so and failed to do so, the judge said. So ultimately it was not a material irregularity. Nor was it an irregularity, and this is incredibly useful, I think, going forward for IPs and supervisors. It was not an irregularity for the nominee not to accept documents from Mr. Rossi during the meeting. So as I said, one of the issues raised by Mr. Karapetian and Mr. Rossi, in fact, was that in the middle of the meeting, which Mr. Rossi claimed was a mess, he was trying to give electronic documents to substantiate the debt of Mr. Karapetian to Mr. Duffy, the supervisor or the nominee. And the judge found that's incorrect. It is for the individual creditors to substantiate their debts, which must be right under the rules. Those individuals who are owed money must step forward to say that they are owed that money and how much they are owed. If a debtor claims that monies are owed to other individuals, it's not for them to substantiate that debt. If the supervisor were to go down that road and merely believe what the debtor themselves said, it would allow the debtor to have an inappropriate power in the IVA meeting. Essentially, the debtor's word would rule over any absence of creditor information. That can't be right, and that's what the judge said. So ultimately, if you're a creditor, you have to put your information in. If you're a nominee, look to see what the creditors have put in. Don't listen just to what the debtor said or just what the proposal says. Proposals can be wrong. Debtors can be wrong. They can forget things. They can elide things. They can undervalue things. So ultimately, that's an important aspect of this case. So as I said, big takeaway is for the creditor to do with these matters themselves, but also the issue of translation. It's not for the nominee necessarily to have to translate documents. If you're a creditor, at the very least, send in a summary of what you're owed on time, including the debt and any substantiating information. Right, I think I might have run a little long, but I will ask Dan to take over.
Thanks, Andrew. Yes, as it says there, I'm Daniel Thorpe. As Andrew introduced me at the start of the seminar, I'm one of the very junior members of Chambers. And as one of those members, I've spent many a happy Wednesday morning in the winding up court just over the way from Chambers, acting for petitioners, supporting creditors, companies themselves. But as we all know, over the last couple of years, those opportunities for those happy Wednesday mornings have been few and far between because of the effects of the pandemic. Now, perhaps as expected, and perhaps as many of you on the Zoom link are experiencing, I think there's certainly been an uptick in those winding up petitions over the last few months in particular. And so today's talk back in business, presenting and restraining winding up petitions. That was my attempt at a relatively catchy slide title, but I'm going to aim to do two things. The first is to just recap where we are, what the live land is in terms of post-COVID corporate insolvency work, the post-COVID corporate insolvency world, at least insofar as winding up petitions are concerned. And the second thing I'm going to aim to do is to go back to basics a little bit and provide a refresher as to what you should be doing and when presenting a petition, and perhaps more importantly, at least insofar as the companies are concerned, what you should be doing to defend one. So as promised, first, COVID. Now, when the COVID restrictions came into force, they came into force across all walks of life, and sensibly, the government also moved to place restrictions on creditors' abilities to wind companies up. As a result, and mostly through the Corporate Insolvency and Governance Act, aka CIGA 2020, related regulations, the creditors were, depending on the point in time, at some point over the last 2.5 years, either restricted from presenting winding up petitions altogether, or at least had to jump through a great deal more hoops in order to get an order putting a company into liquidation. So I suppose the best place to start is, where are we now? Perhaps people rejoicing that the Corporate Insolvency and Governance Act 2020, CIGA 2020, expired without renewal on the 31st of March. There's a very slight hangover, I should say, well, and expired so that the requirements no longer have to be complied with, obviously. I should say there's a slight hangover, and that is there is some petitions still rumbling on that were presented on or before the 31st of March, which will therefore still have to comply with the requirements. And namely, I think the most important one of those is the Schedule 10 notice. Hopefully, as many of you will know, the Schedule 10 CIGA required that notice be delivered to the company as a potential target of a winding up petition, which gave the company 21 days to come back to the potential petitioner with proposals to pay the debt, and also tell the company that unless you do so engage, we are going to present a petition against you. It's also introduced a £10,000 threshold to be able to wind up a company. As I say, it's only a slight hangover because for obvious reasons, those petitions are fading away. But in circumstances where petition hearings have been adjourned, etc., some still are rumbling on. But in my experience, the insolvency judges or the ICC judges are willing to find a way to either waive more on waiving formal requirements later, or just find a way around non-compliance with those sections. The significant restrictions still in force, I think, as far as winding up petitions are concerned, is what's written on the slide there, the Commercial Rent Coronavirus Act 2020, which in its introductory text says, as I've quoted there, it intended to make provision enabling relief from payment of certain rent debts under business tenancies adversely affected due to coronavirus. Now, a colleague of mine in Chambers, James Fagan, has recently given a detailed talk on the provisions of that act. And obviously I'm going to have to direct you there for an in-depth look into what it provides and the scheme it tries to promote. But given this talk is designed to touch on some of the restrictions in place when trying to present petitions, I'm going to blitz through them very quickly. But as I say, the detail can be found on our various social media channels and the slides and the talk that James gave a few weeks ago. So the first thing to bear in mind, let's say you have a client who is a landlord, a commercial landlord, and wants to petition for the winding up of its commercial tenants. Does this act make a difference to them? In theory, yes. So it applies to business tenancies, and that's a tenancy to which the 1954 Landlord and Tenant Act applies. Obviously, practitioners will need to look at the tenancy in question to see whether that act does apply. If you are dealing with a business tenancy, what sort of debts are covered. And the phrase coined by the Act is, as it says there at the second bullet point, protected rent debts. And it is in respect of those debts which the Act seeks to restrict petitions from being presented. So what is a protected rent debt? And that's defined in sections 2 and 3. And I should say here that rent is used as a catch-all phrase, but it does catch charges under tenancies which I suppose in ordinary parlance would go beyond rent. Service charge, for example, is something I've put on there. But what is a protected rent debt? A protected rent debt is a debt which arises from rent under a business tenancy, where the tenancy was adversely affected by COVID. That is defined in section 4 of the Act, adversely affected, which means when the business was closed from any period from the 2 p.m. on the 21st of March, which I think, casting our minds back to that awful period of time, was the first day of lockdown over 2 years ago, to the 18th of July 2021 in England and the 7th of August in Wales. So if the business was closed from any period during that time, the tenancy was adversely affected by COVID. The second requirement, and it's a cumulative requirement, is that the rent is attributable to a period of occupation by the tenant during the protected period. The protected period, again, it covers the same period of time as I've set out on the slide there, with a potential extension from those July and August dates, where the business was obliged to remain closed for longer than that period. Again, very difficult and harrowing to cast our mind back to that period of time. But I certainly remember that there was a staged reopening of various types of business, which meant, amongst other things, that I think we all had to wait slightly longer for a haircut. So that is that's the broad scheme of the Act. What is the real significance for us as insolvency practitioners? And you can see there my first example of a very basic stock image. The whole purpose of the Act, at least in my view, is to point parties towards arbitration. So the combined effect is section 27 and schedule 3 of the Act, meaning that landlords cannot present winding up petitions in respect of an inability to pay protected rent debts during the moratorium period. The moratorium period is essentially 6 months from the day on which the Act came into force. So that was the 24th of March 2022, I beg your pardon. So during that period, a landlord cannot petition for the winding up of its tenant based on protected rent debts or non-payment of protected rent debts, unless the dispute has been referred to arbitration on the terms of the Act. That arbitration is concluded, but has concluded not to the satisfaction of the landlord, and the landlord still wishes to petition the tenant. So that is where we are really in terms of COVID restrictions on winding up petitions. I think the key thing to bear in mind is if you have a client who's looking to wind up a company, or if indeed you are a tenant or you are representing a tenant which is faced with the prospect of being wound up, this Act is very important. And I think post-COVID, this is really the principal restriction that we need to bear in mind going forward. So against that background, I thought a back to basics session would be useful on the basis that those restrictions have all dropped away. I'm going to talk about two things. The first is the various hoops you have to jump through when presenting a petition, and the second, as I mentioned earlier, was in other words, how to defend a petition. And for those of you in the audience who've done that before, you'll know that one of the most common ways of doing that is looking to restrain the presentation or advertisement of the petition via an injunction. But back to the start, back to basics, presenting petitions. Section 122 of the Insolvency Act provides for various situations in which the company may be wound up by the court. The most common and therefore important for our purposes is the ground at subparagraph 1F, which states that a company may be wound up if it is unable to pay its debts. Over the page to section 123, the Act talks about situations where the company is deemed to be unable to pay its debts. And I've listed them in shorthand there. In essence, where a written demand, a statutory demand, is left unanswered for 3 weeks, where execution of other process is returned unsatisfied, where it is proved to the satisfaction of the court that the company is unable to pay its debts as they fall due, or where it is proved to the satisfaction of the court that the value of the company's assets is less than its liabilities. And then section 124 provides for who may petition the court to wind the company up on the basis that one of those situations has occurred. The company itself, the directors of the company, creditors, or contributories. And I've put there subject to conditions. If a contributory is looking to wind up a company, there are a couple of conditions which the Act makes them subject to, but in this whistle-stop tour, I'm not going to go into the detail, but you'll see from section 124 what those restrictions are. Now, on that basis, a creditor comes along and asks you to petition for the winding up of a company on its behalf. Before we get there, just a brief word of warning. It's a cardinal rule of petitions to wind up companies that the debt must be undisputed. This is a threshold test to establish standing, and the leading case there is Mann and Goldstein, which in this context, or in the context of disputed debts and winding up petitions, pretty much contains everything you need to know. But the basic idea that is that a person is not a creditor unless the debt he or it is asserting is undisputed. In other words, if it is not disputed by the company in good faith on substantial grounds. Now I'm going to go into more detail on disputed debts slightly later on, but my top tip is that it's very important that clear instructions are taken and advice is given to any potential creditor before the steps I'm about to outline are taken. And the recent case of Schettini on the slide there is a good example as to why the potential or the petitioner, the potential creditor, was ordered to pay the cost of the company on the indemnity basis for the cost the company had incurred in defending the petition. This is frankly because the debt was disputed. And as a quick aside, in that case I mentioned there, 6798 of 1995, this was a slightly odd situation, but it was actually the lawyers for the petitioner who were ordered to pay the cost of the company on the indemnity basis. And I suppose for our purposes, this is potentially concerning. And what happened there was that it was the solicitor who had, only the solicitor, I should say, who put in evidence in the form of an affidavit in support of a petition. And this was a petition debt which was allegedly due but had never been demanded. The solicitor's affidavit said that I have perused the accounts and I've received very strong instructions and I am happy to put this affidavit forward on that basis. But I've advised my client that this is a very high risk strategy and the petition may well be struck out if it's issued. The phrase nail in his own coffin comes to mind, but the court had no sympathy with that and basically held, Mr. Justice Chadwick held, that the solicitor's conduct fell outside of the conduct of a reasonable solicitor by not only allowing his client to do this, but also putting evidence in his own name, despite knowing, or should ought to have known, that this was doomed to fail. So, moving on, you've given that warning, you've given that advice, you're happy that the debt is, or you, at least at the moment, is not disputed. First things first, you need to draft the petition. Now, just as an aside, a statutory demand, as I've said there, is not mandatory, as it is in the context of a bankruptcy, but it is useful. And my approach would be to serve one because of the deemed inability to pay its debts under section 123, as we talked about earlier. So get one of those in. as I say, it's not mandatory. Once that has gone unanswered for 3 weeks, you may want to draft your petition. There's no standard form. There's no prescribed form, I should say. There's no mandatory prescribed form, but there is a standard form available on the government website, and that is most commonly used, in my experience, by petitioners. It's certainly quite useful if you can find an up-to-date one. A word of warning that if you find an old one, it may not refer to the correct insolvency provisions of the insolvency rules. But as I say, standard form does refer in the margin to the rules you need to satisfy. And those rules, in terms of drafting, are 7.5 and 7.6, as I've said there. Rule 7.5 is very prescriptive. It's mandatory. It talks about everything that needs to go on the face of the petition, and I think that is everything that you would expect, such as the company name, company number, the registered office of the company, the size of the debt, etc., etc. And 7.6 requires the petition to be verified by statement of truth. Now, this verification can come on the face of the petition itself, but most commonly, again, in my experience, in practice, that verification comes in the form of a separate witness statement, often in the name of the solicitor for the petitioner, which refers to the petitioner. And there's no bar on this. The verification can come in a separate document, which states that the contents of the petition are true. But the reason for this is because in Rule 7.6 there is a requirement that the petition states whether or not these will be COMI proceedings, in other words, whether the centre of main interest of the company is within this jurisdiction. And there is also a requirement to state whether the EU regulation, as retained in the law of the United Kingdom, applies. And there must be evidence put in with the petition which states what the appropriate situation is and why the petitioner believes that to be the case. At the bottom there, I've talked about which court. And again, in my experience, most winding up petitions are presented to the High Court, but the County Court does in fact share concurrent jurisdiction with the High Court to wind up companies where the company's paid up share capital does not exceed £120,000. So the County Court does remain an option, and I should say that that is subject to the £120,000 limit, but also the company must be outside of the London Insolvency District for you to use a County Court. If it's in the London Insolvency District, it must be in the High Court. But for all other cases, the County Court can be used. Always nice to have a choice, I suppose, but I don't really see why you would choose the County Court. In the High Court, you'll have the benefit of the electronic filing system and the far superior administration, which means your petition will likely be dealt with more quickly and with less of the pain and suffering that many of us on this call will no doubt have experienced. I know I certainly have, which accompanies the case management and listing process in the county courts across the land. Moving on, service. And again, this is just a whistle-stop tour, just points to note. I'm not going to go into detail of the petitions, but Rule 7.9 of the Insolvency Rules, the petitioner is to serve the company. You will find some more information in Schedule 4 of the Insolvency Rules, and in particular, paragraph 6 of Schedule 4, the requirement about a certificate of service. Most commonly, as many of you will know on the call, a process server is engaged who goes around to the registered office and drops the petition and the various papers into a letterbox or hands it in at reception, etc., etc. Rule 7.10 deals with notice, which is frequently referred to as advertisement. And you must give notice of the petition in the Gazette not less than 7 business days after service and not less than 7 days before the hearing. And that Gazette notice must be filed at court no later than 5 business days before the hearing. And with a certificate of compliance, which again, at Rule 7.12, is simply a certificate signed by the solicitor for the petitioner attesting that all of the rules that I've just gone through have been met. Another requirement which, in truth, I've never been asked for, and the court doesn't seem too worried about it anymore. Perhaps that is a symptom of the winding up list that took place via Microsoft Teams over the course of the pandemic. Petitioners are required to file a list of appearances with the court. So in other words, if you've received notice from somebody that they are going to appear on the petition hearing, you need to put that on paper and file it at court. So in theory, the court knows what's going on. Top tips, 3 top tips. Now, these are things which I have heard from the ICC judges in court, and I don't think they're found anywhere, certainly not in the rules, and certainly not in the Act. But 3 things I think that are worth bearing in mind. The first is that generally petitions do not require hearing bundles. I was appearing in a list not so long ago before Insolvency Company Court Judge Prentice, who remarked with a slightly tongue-in-cheek and with a smile on his face, as tends to be his style, but he had received 3 boxes of papers for a winding up petition hearing. That's not appropriate because, as anybody who's listened along to the list knows, each case is dealt with usually in about 30 seconds to a minute. ICC Judge Mullins previously said in that list that if the case truly requires a bundle, that's a pretty good sign that it's not suitable for hearing in the general winding up list, and a longer hearing should be listed at some other point. Second, happy Monday, as I've put there. ICC Judge Mullen has also indicated when I was in the winding up court that if you want something to be considered, if you want something to be before the judge in the winding up list, it has to be filed at court via CE file by no later than Monday lunchtime. And I think that's quite important to bear in mind now. So in my experience during the pandemic, the judges were reasonably open to things being handed up to them on the day or emailed to the clerks on the day. And I think that's because the list was generally a lot shorter. And so there was a lot more time to deal with individual cases. But now, in my experience, if a document is not before the court, and it's been filed after that Monday lunchtime rough cutoff point, you'll simply be adjourned, and you'll have to come back next week, the week after, etc. And obviously, that's not only frustrating, but also leads to the incurrence of further costs. And the third tip, and that cartoon there, not that I know very much about baseball, but at 1 strike and you're out. You generally get 1 opportunity to present a petition in the list, and something's wrong with it. So that could be an error in the drafting, a typo. You may have got something wrong. You may have not filed something. You may have not served it. You may have not advertised it. That's fine. And generally, the first time around, the petition will be adjourned and you'll be let off. Second time, I think your counsel will face generally an uphill struggle to try and convince the judge why your petition at the second time of asking should not be dismissed. I'm conscious of the time, so rattling on. The hearing itself, the usual compulsory order is a little bit of jargon that's thrown around by people like me and the judges in the winding up court. That simply means that the company is wound up and the costs of the petition are paid as an expense of the liquidation. As I've said, if there are missing documents, you will be given a chance to go away and sort that out if it's the first time of asking. Second time, a bit more difficult. If there are errors in the petition, the judge there, I've said, and I've quoted Rule 12.54 of the Insolvency Rules, the judge has a discretion to waive a formal defect with the petition. This could be a typographical error, for example, or an error in the company's name, or something was filed 4 days before the hearing instead of 5 days before the hearing. Generally, if the judge is satisfied that no prejudice has been caused to the company or to potentially other creditors, you will get away with it. If On the other hand, you've got the company's name wrong, such that there is a risk that the company could not be identified based on how you've named it in the petition. You're likely to be given permission to amend and come back. If, as I've said, it's the second, third time that you've made an error, I think it's probably going to be dismissed and you'll have to start the process again. Lastly, directions. If the company comes along and presents credible proposals as to the payment of debt, or comes along and says this debt is disputed, the debt's not actually due, or something along those lines, the chances are you'll get directions, and this will be adjourned to a far longer hearing, almost like a trial, where you will be able to go in depth into exactly what the company's saying and why it is wrong, you would say, as the petitioner. So that's petitions, whistle-stop tour. Restraining petitions. Continuing our tour through mediocre stock images, how to defend a winding up petition. I think there are three options really, depending on the stage at which you are being presented with one, or I should say, if one's being contemplated. If you've received a statutory demand or another, what's sometimes called winder letters, a letter threatening a winding up petition, what you should really be doing is looking at an injunction to restrain presentation of the petition. If you've been presented with a petition, if you've been served with a petition, but that petition has not yet been advertised in the Gazette, I think you're looking at an injunction to restrain advertisement. If you've not had the opportunities to do either of those things, and you find yourself served with a petition which has been advertised, you need to contest the petition by essentially turning up to the hearing and saying this is contested and going along to a disputed debt hearing. Why does it matter? Why is it important for companies to restrain petitions? And in my view, the two main reasons are there. The first is Section 127 of the Insolvency Act. If the company wants to carry on trading but a petition has been presented, any disposition, as it says on the slide, of the company's property, any transfer of shares, any alteration in status of the company's members made after the commencement of the winding up is, unless the company orders otherwise, court orders otherwise, I should say, void. Section 129 of the Insolvency Act states that the winding up commences when the petition is presented. Now, once your petition is advertised in the Gazette, it's common practice for banks to freeze the company bank accounts in order to protect their position and protect the petition of the company, protect the position, I should say, of the company's creditors. In that situation, you, the company, are potentially subject to a whole load of faff and aggravation. You'll have to go to court and obtain validation orders to reverse the idea that these transactions are potentially void. So an injunction to restrain presentation and restrain advertisement will put the brakes on that process. The second aspect is almost a soft disadvantage, and that's reputation. Petitions are class remedies, they're matters of public record. An advert goes in the Gazette to say this company is the subject of a winding up petition. That's not good news if you're a company, and certainly not good news if you're a potential customer or other party related to the company. It'll also have an adverse effect on your credit rating. It may also alert other creditors to the fact that you're in trouble, and they might decide that they want to jump on the bandwagon, and then you will potentially be fighting against 2 creditors, 3 creditors, 4 creditors, rather than just the one. So that's why that's important to bear in mind. The main ground for restraining the presentation or advertisement of a petition, and it's the same test either way, is that, as I said earlier, is that there's a disputed debt, or the debt's disputed on substantial grounds. And the Mann and Goldstein case, which I referred to earlier, is helpful. But I actually find that this summary, and I've reproduced some of it on the slide there for you, apologies for the density of the text, but Mr. Justice Norris in Angel Group Limited and British Gas talks or summarises the principles. And I'm not going to read it all out to you, but you can see there that subparagraph B, from paragraph 22 of the judgment, he talks about that threshold standing test that we referred to earlier. Paragraph C, a dispute will be substantial, will not be substantial if it has really no rational prospect of success. And you can see down there at G that this is similar and has been said to be similar to the summary judgment test. But at E, and that underlined section there, the true rule is that it is not the practice of the company's court to allow winding up to be used for the purpose of deciding a substantial dispute raised on bona fide grounds. The effect of presenting a winding up petition, as we've just seen, and advertising that petition, is to put upon the company a pressure to pay, which is quite different in nature from the effect of an ordinary action. In other words, if you know that this debt is disputed, you should be going down the Part 7 route, whether it's on a contract or some other debt has arisen in some other way, and having your dispute out in that forum, not in the winding up list. And so, again, I'm conscious of the time. A toolkit, I've called it. 4 things that you really should be doing when you're faced, or when your client is faced with a petition. What stage is the petition at? Is it threatened, or has it been presented? If it's threatened, you need to get onto the petitioner straight away. If it's presented, I suppose you need to do the same thing, actually. The second thing to consider, what is your client's position with respect to the debt? Is it admitted? Is it part admitted? Is it disputed? Depending on the answer to that question, my advice, or my informal advice, or my general advice would be to go to the petitioner and discuss an undertaking. It's common practice, as I've said there, for the company to request an undertaking from the petitioner after explaining why the debt is disputed. The undertaking, and that's an undertaking not to present or not to advertise the petition, will potentially avoid those consequences that I've been through previously. It also protects the company's position on costs. That's the Scatini case and the other company case, which I referred to earlier. They are classic examples of where an undertaking was not given, and so the company was forced to apply for an injunction. In both of those cases, the company got its costs on the indemnity basis. The fourth thing, directions. Once you've got that far, if you manage to secure an undertaking, you should look to try and agree some form of directions. In other words, when are you putting evidence in? When is the petitioner putting evidence in? When should the final hearing be? How long should the final hearing be listed for? In the ordinary way. And I've talked about disputed debts. I should say another stock image there to make things a bit more interesting, potentially, is that there are other grounds on which to ask for an injunction, or to generally contest a petition, aside from there being simply a disputed debt. And the first comes from, again, leading case there, Re Oil. If the company has a cross-claim based on substantial grounds, which reduces the debt, that can be grounds to get an injunction, or to contest the substance of the petition. If there have been procedural errors, and again, I spoke about that earlier, it's common to hear a company being represented in the winding up court and then saying this petition should be dismissed because the petitioner has had 5 chances to get this right and has not got it right on any occasion. And the last is on jurisdiction. Do the English courts have jurisdiction to wind this company up? Is it a company registered in this jurisdiction? If not, does it have its centre of main interest here? Does it have an establishment here under the EU regulations retained in English law? These are all questions, I think, which require detailed consideration, and again, go beyond the nature of this talk. But all that's left for me to say is thank you very much for listening.
Yeah, thanks for me as well. I'm just typing an answer to this last question, so I'm going to try to do two things at once. In fact, I'll just answer it orally to whoever anonymous attendee sent this, who we were discussing in the questions issues of the recent Dear IP letter number 147 sent to insolvency practitioners by the Insolvency Service, which provides the IVA Standing Committee, which essentially sets some of the terms and conditions for the IVA protocol, which applies to IVAs. It's an incredibly convoluted discussion, but in essence, there's natural tension between the terms and conditions, which say, or it says decision-making procedures need to be followed in order for amendments or variations to IVA proposals. In my mind, that would exclude deemed consent, because deemed consent is not a decision-making procedure under the Insolvency Rules. It is within Part 15, where the decision-making procedures are set out, but it is specifically set in contrast to decision-making procedures. And the most recent Dear IP letter actually says that supervisors should be using deemed consent. Looking at this just very quickly, without having thought about it in depth, I would be extremely concerned about trying to use the deemed consent procedure, which would seem to run directly against the terms and conditions. I don't think there's an amendment to the terms by the Dear IP letter. It says it should be read in conjunction, but it certainly is not a change to the insolvency rules. It's not a change to any agreed terms and conditions in the IVA protocol. And I would have significant concerns about using that procedure and opening myself to a challenge. It might be I'm wrong, because I've just done this on the fly, sat here when I'm desperate for a cup of coffee. But I just don't read it as allowing deemed consent to be used. And I certainly don't believe the Dear IP letter actually amends anything. That's just my view in a nutshell. I was writing that, but I'll send what I wrote just to the lovely person who asked that question. Very difficult, interesting question, very esoteric. Loved it.
I think that's it from us. So wishing everybody a very happy Thursday, a good weekend, and again, thanks for listening.